Okay, good evening class. We are now on our fourth lecture series for the midterm for the subject Business Law 223. Tonight we are going to discuss discharge of instrument and parties, secondary liable, and we also would like to discuss BP22. First of all, we would like to credit or to mention the following researchers who made this PowerPoint possible. Credit to Miss Alma Jane Pellegrino, Miss Gian Monsor, Mr. Gian Monsor, Mr. Guainet Mordeno, Miss Honey J. Navari, Tricia May Ondora, Alexa Organiza, and Pirang Reka. Now, as our usual norms, we conduct pre-test and post-test questions. And here are the following. Define BP22. Question number 2. What are the elements of the offense under the bouncing check law? Number 3. What is meant by discharge of an instrument? Number 4. What are the methods of discharge of secondary parties? Number 5. For how long is the imprisonment imposed for any person who makes and issues any check for value with insufficient funds? Number 6 question. How much is the fine imposed to any person who makes and issues any check for value with insufficient funds? Number 7. When is the making, drawing, and issuance of a check out of insufficient funds presented to be deemed as a prima facie evidence of knowledge of such insufficiency of funds or credit? Number 8 question. State the 4 kinds of check covered, whether present or post-dated or issued in payment. Number 9. What is malum prohibitum or mala prohibitum? And number 10. What is the grace period that a dishonored check should be fully paid by a drawee so as not to become an evidence of insufficiency of funds? Okay. Question number 1. Define BP22. The answer is BP22 is an act penalizing the making or drawing and issuance of check without insufficient funds or credit and for other purposes. Question number 2. What are the elements of the offense under the bouncing checks law? Answer. 1 is issuing a check to apply any account or for value, and then knowledge at the time of the issue upon presentment. And then dishonor of insufficiency of funds. Number 3 question. What is meant by discharge of an instrument? Answer. The parties who are liable on the instrument has no more liability. Number 4. What are the methods of discharge of secondary parties? Answer. Any act which discharges an instrument. Number 2. Intentional cancellation of signature. Number 3. Discharge of prior party by act of a holder. Number 4. Valid tender of payment. Number 5. Release of the principal debtor by act of holder. And number 6. Extension of time. Number 5 question. For how long is the imprisonment imposed to any person who makes and issues any check for value with funds? Answer. Not less than 30 days but not more than 8. Number 6. How much is the fine imposed to any person who makes and issues any check for value sufficient funds? Answer. A fine of not less than and not more than double. Number 7. When is the making, drawing, and issuance of a check out of insufficient fund presented to be deemed as a prima facie evidence of knowledge of such insufficiency of funds or credit? Answer. Within 90 days from the date of the check. Number 8. State the 4 kinds of check covered, whether present or post-dated or issued. Answer: accommodation check, guarantee check, memorandum check, and foreign check. Number 9. What is mala prohibita or answer? These are acts which made evil because either it is a law prohibiting the same or punishable under. Number 10. What is the grace period that a dishonored check should be fully paid by a drawee so as not to become an evidence of insufficiency of funds? Answer: within 5 banking days after receipt. Let us discuss thoroughly. What is meant by discharge of an instrument? Discharge of an instrument means the parties who are liable on the instrument has no more liability or in the instrument. Section 120, it is said that when a person secondarily liable on the instrument are discharged, a person secondarily liable on the instrument is discharged: A. by an act which discharges an instrument, by the intentional cancellation of his signature by the holder, C. by the discharge of a prior party, D. by a valid tender of payment made by a prior party, E. by release of the maker or drawee. The holder does not want any more to be paid by the drawer or drawee. F. by agreement to extend the time of payment between the holder and the maker or drawee. Meaning and effect of discharge of instrument. Discharge of an instrument means release of all parties, whether primary or secondary, from the obligations arising thereunder. It renders the instrument without force and effect, and consequently it can no longer be negotiated. What are the methods of discharge of secondary parties? 1. Any act which discharges an instrument. Number 2. Intentional cancellation of signature. Number 3, discharge of prior party by act of holder. Number 4, valid tender of payment. Number 5, release of the principal debtor by act of holder. Number 6, extension of time of payment. Section 21 says, right of party who discharges an instrument. Where the instrument is paid by a party secondarily liable thereon, it is not discharged. But the parties who paying it is remitted to his former rights as regards to all prior parties, and he may strike out his own and all subsequent endorsements and again negotiate the instrument, except A. where it is payable to the order of a third person and has been paid by the drawer, and where it was made or accepted for accommodation and has paid by the party accommodation. What are the effects of reacquisition by prior party? Payment at or after maturity by a party secondarily liable does not discharge the instrument. It only cancels his own liability and that of parties subsequent to him. Negotiation by prior party. The first clause contains the provisions: 1. That the instrument is not discharged and that it may again be negotiated. Do the exceptions in subsections A and B apply to the rule that the instrument is not discharged or to the right to further negotiate them? Section 122, renunciation by holder. The holder may express renounce his rights against any party to the instrument before, at, or after its maturity. Meaning of renunciation. The term renunciation describes the act of surrendering a right or claim with or without recompense. While there are decisions to the contrary, it has been held that Section 122, when read together with Sections 119 and 120, applies only to renunciation by a unilateral act of the holder, a release without duration. Cancellation, Section 123. Let's talk about cancellation and intentional burden of proof. A cancellation made unintentionally or under a mistake or without the authority of the holder is inoperative. but where an instrument or any signature thereon appears to have been cancelled, the burden of proof lies on the party who alleges that the cancellation was made unintentionally or under a mistake or without authority. When cancellation inoperative. Cancellation of an instrument is not limited to the writing of the word cancelled or paid or the drawing of crisscross lines across the instrument. It includes tearing, erasure, obliteration, or burning. It may be made by any other means by which the intention to cancel the instrument may be evidenced. If the cancellation is made, 1. Unintentionally, or by mistake, or through fraud, or without authority, it is inoperative. Cancellation, however, is presumed to be intentional. Hence, the burden is on the holder claiming its ineffectiveness to overcome the presumption by contrary proof. Section 124, Alteration of Instrument. Effect of. When a negotiable instrument is materially altered without the assent of all parties liable thereon, it is avoided, except as against a party who has himself made, authorized, or assented to the alteration and subsequent endorsers. But when an instrument has been materially altered and is in the hands of a holder in due course, not a party to the alteration, he may enforce payment thereof according to its original tenor. Effect of alteration of instrument. Alteration by a party. Alteration by a stranger. Right of a holder in due course. Section 125. What constitutes a material alteration? Any alteration which changes the date, the sum payable either for principal or interest, the time or place of payment, the number or the relations of the parties, the medium or currency in which payment is to be made, or which adds a place of payment where no place of payment is specified or addition, which alters the effect of the other change or instrument in any respect, is material or change or alteration. So that's the meaning of material alteration. Now let's go to banking law. Now, let us define in the banking law what is meant by a check. A check is a bill of exchange drawn on a bank payable on demand. Where can you find that? It's found in 185. Section 185 of the Negotiable Instrument Law. What are stale checks? Stale checks must be presented for payment within a reasonable time after its issue, or the drawer will be discharged from liability thereon to the extent of the loss caused by the delay. This is found in Section 186 of the Negotiable Instrument Law. Other meaning of stale checks are those checks which, when issued, has not been encashed within 5 or 6 months. That could be stale checks. Mala in se. It's an acts which are inherently evil. It's punishable under the revised penal code. Example of mala in se is istapa, which is Article 315 of the revised penal code. What is mala prohibita or malum prohibitum? It is an act which made evil because either it is a law prohibiting the same and it is punishable under special laws. Example, BIBO. What is bouncing check law? BP22. It's an act that penalizes the making or drawing and issuance of a check without sufficient funds or credit and for other purposes. Crimes committed by issuing a bouncing check. Violation of Section 1 of BP22. Istafa under Article 315, Paragraph 2, Subparagraph D of the Revised Penal Code. What are the crimes committed by issuing a bouncing check? What are those? How? By making, drawing, and issuing a check knowing that the issuer has no sufficient funds, and the said check was dishonored. Take note, it must be dishonored. And then by making, drawing, and issuing a check while having sufficient funds but failing to maintain such funds within 90 days from the date of the check, and said check was dishonored. Elements of the offense: issuing a check to apply any account or for value. Knowledge at the time of issue upon presentment. What else? Dishonor of insufficiency of funds. What else? Let us talk about notice of dishonor. A notice of dishonor is a notice that is given to the drawer and informing him or her that the check he or she issued was dishonored by the drawing bank, and the reason behind such dishonor, and that she has 5 days to make good of the check. It is said so because after 5 days, when you fail to make good of the check, that becomes a prima facie evidence that you're issuing a check which has no sufficient funds. A notice of dishonor must be made in writing, and oral is not enough. Where can you find that? Under our obligation and contracts, because it is a transaction. Must be in writing, made by a drawee or the payee or both. What else? It must be received by the drawer. And then, absence of a written notice of dishonor received by the drawer is fatal to the case of violation of BP22 against said drawer. Why is it so, class? Why is it so that under BP22, a written notice is necessary? The reason because under the law, in civil law, it is said that no delay, no demand, no delay. So, a written notice must be necessary for you to declare, for you to manifest to the court, show the court that obligor is in delay under BP22. What are the defenses when you are sued for a crime of BP22? One, that there has no notice of dishonor. Prescription, the offense has already prescribed. What else? Duplicity of offenses. What else? There was forgery. There was lack of necessary signature to the check. Due payment of performance obligation. Then failure to present the check for payment within 90 days from the date appearing on the check. Stale. Or dishonor with a mere stamp in the check or stamp payment. Now, checks that are covered. Checks which are broad enough to cover all kinds of check. BP22 is broad enough to cover all kinds of check, whether present or postdated or issued in payment of pre-existing obligation. Take note, pre-existing obligation or give in mutual or simultaneous exchange for something of value. Accommodation check, guarantee check, memorandum check, foreign check. These are the checks that are covered under BP22. Now, checks without insufficient funds, Section 1. What are those? Any person who makes or draws and issues check knowing at the time of the issue that he does not have sufficient funds, which check is subsequently dishonored by the drawee. That becomes check without sufficient funds. What else? It is drawn against funds. Daif, liable for BP22 and then account closed. Or drawn against undeclared deposit or not liable by BP22 because there is undeclared deposit. Section 2, evidence of knowledge of insufficient of funds. For this presumption to raise, the prosecution must prove the following: that the check is presented within 90 days from the date of the check, and then the drawer or maker of the check receives notice that such check has not been paid by the drawee, and the drawer or maker of the check fails to pay the holder of the check the amount due thereon, or make arrangements for payment in full by the drawee of such check within 5 banking days after receiving notice that such check has not been paid by the drawee. Now, what are the penalties of BP22? Imprisonment, not less than 30 days, but not more than 1 year. What else? Fine, not less than the money, the check, but not double the amount, but no more than the double the amount. Or both fine and imprisonment at the discretion of the court. Now, take note that the Supreme Court Administrative Circular 12 of Series 2000 mandates that as much as possible under applicable circumstances, only fine shall be imposed as penalty. And the same circular did not remove the penalty of imprisonment. It only urged judges to lesser penalty to best serve the ends of criminal justice. Now, if the worthless check was issued for fraudulent purpose, there is no stopping of giving out the penalty of. And that, thank you for listening and good night. I hope you have listened, study well, and be ready for your midterm exam.